Hi everyone, welcome along today. I'm your gracious host for our small but dedicated gathering. Well, if you're like me, you've been covering the Carlos Ghosn case for the last couple of months, which has exposed the yawning gaps in our knowledge about Japan's justice system and forced us to kind of scramble in our comparisons with our own countries. So tonight's talk is very well timed. Tina Saunders of Temple University, Japan, is going to discuss journalism and justice. She's going to talk about how to train journalists to report the Japanese judicial system compared to the American system, and introduce strategies for covering corporate scandals. The seminar will also look at potential legal hazards for journalists and effective reporting techniques, and in the context of libel laws. Tina is director of Temple University Law School, Japan campus, and an associate professor of the instruction in law. My apologies. She is an experienced commercial litigator and teaches torts and civil procedure at Temple Law Japan. My job is just to get out of the way and let her to speak. You won't see me again till the end unless I get inspired to ask you a question. Onegaishimasu.
Thank you. All right, thank you for joining. David, thank you for such a gracious introduction. I'm really excited to be here tonight because now is a very interesting and thought-provoking time to be in Japan, particularly when it comes to corporate governance. And oftentimes you can see that in the past 6 months or so, the headlines have been dominated by this huge scandal that's going on with the Nissan as well as Ghosn. And so tonight we're going to focus broadly on just what is the legal system here in Japan. There's a lot of misperceptions about what is the system and how the system is supposed to work in order to protect the rights of individuals as well as companies. And so tonight we're going to do a bit of educational learning about what is the system, what are the sources of law, having an understanding of what you as journalists need to know as far as your protections in reporting and your risk or exposure to liability in reporting. And then we'll turn to some examples about corporate scandals that have happened here in Japan, and that will lead the discussion about what you as reporters or the media, what is your responsibility in terms of reporting on legal matters here in Japan. Okay, so let's get started. So one thing I should say is that I'm a teacher at heart. So I'm not the talking head professor type. If you have some question, please raise your hand and ask your question. This is meant to be an engaging discussion, and I'd like for you to think about that engagement by asking questions about something that I might say or something that you don't know. So I'm not going to take a Q&A at the end. We'll take it throughout, so that way we can have an engaging discussion about some of the things that we're discussing. Okay? Okay, so first I'd like to start off by posing one basic question to you. The idea is, what is your responsibility in reporting on legal matters? We often think about the reporting of legal matters as only related to big scandals or something that's happening in the news that will generate headlines. But maybe part of the broad idea about reporting on legal matters has to do with giving information to the public. Because you imagine that most citizens, it doesn't matter what country you're from, most citizens don't actually interact in the legal system. We're not all routinely being arrested, for example, or we have no understanding of what that system is. And so there is the idea that the media, you really are the disseminators of information. Information is power. The more information you give, the more that the public knows. The more that the public knows, the more that we're informed. And so because you have this very real relationship between the information that you as media are putting out and the information that we as just regular citizens are taking in, it almost brings you to a level of having a big power. Big power to explain what is the system. Big power to talk about what are injustices. Big power to explain the rights that we have as citizens. And so it's in this context that we're going to talk about what it means to do legal reporting in Japan. Okay? All right, so what I'd like for you to think about is this idea of a proactive versus a reactive reporting. And what I mean by that is this. You have two situations that typically occur when it comes to legal matters that are happening just in society. It could be that somebody got into a fist fight and they were arrested and then become a part of the system. Or it could be something as big as tax fraud or accounting scandals. And the two basic ideas are that, one, if you're proactive, then you're thinking about exposing bad behavior before that behavior is made known to the public. Exposing behavior before that behavior becomes a part of the actual legal process. So the idea that you're exposing bad behavior is a way of what we would say is proactive reporting, especially on legal matters, because you're primarily focusing on usually violations of law or violations of social norms. And both of those instances, the only way that we as the public will know about it is if you tell us, right? The other side of it is more of a fact-based, this happened and that happened, and then next, something else happened. That is the idea of reactive reporting. So a prosecutor, for example, like the Ghosn case, makes this huge show with the police showing up at the airport. And we have reporters taping, quite literally, Ghosn being arrested at the airport. That is the start of the legal process when you really think about that. The start of the legal process is from arrest if it's in the criminal arena. And so once that legal process starts, now you're just reporting, okay, well, this happened. Ghosn was arrested at the airport, as opposed to exposing bad behavior. And so when we're talking about this idea of proactive versus reactive reporting, especially in the legal field, we always want to think about who are the key players. The key players are those that are tasked with, and they have an actual responsibility to, mete out justice, to make sure that laws are upheld, to make sure that we're following the process, whether it be in actual laws or social norms. And so when you're thinking about, well, who are we reporting on, then that would be the key legal players. That would be the police. That would be the lawyers who are representing or prosecuting defendants. That would be the legislature, because they create law here. And so you're always thinking about what process or what stage in the process are you in terms of how you're creating the narrative for legal reporting, right? So when we talk about this idea of creating this narrative, it has to start from two basic ideas. One is understanding what is the actual legal system. And number two, understanding your protections and risks within that system. So we'll start first with what is the legal system. And I don't want to make this a civic lesson so that we're back in high school again and you are learning about court structure. But I want to make a big point about Japan's legal system. Generally, most countries are organized under two types of legal systems. One is called the civil law system, and the other is the common law system. I assume that everyone's heard of this idea, right? Okay, so what you need to understand is that because the legal systems are created in a certain way, that in turn determines the way that the legal process happens. That determines the way that, for example, Ghosn could be arrested within the criminal system. And so with civil law is basically code law. That means that the legislature here, the Diet, they are tasked primarily with making the rule of law within Japan. And civil law tends to be very, very, very detailed. They don't have these broad statements of law. If it's a law that's related to financial services, then it's a very detailed step-by-step explanation of what are the definitions, what are the rights and entitlements, what are the exposures to liability under the law. And so because code law, here in Japan, code law was actually developed from, in part, the German and French systems. And that portion of the legal system was imported here to Japan. We know that the Constitution in Japan was largely, in part, made around the US Constitution. But when it comes to the structure of government, that was largely taken from Germany and France, not the US. And so because you have this civil law system, one of the huge characteristics of the Japan system is the fact that the judges here, courts, do not create law. They don't make law at all. They are tasked with interpreting and enforcing the law. And that, in a sense, creates a lot of stability, because judges no longer have the task of needing to understand and create what should be the law that governs some part of society. All they have to do is interpret and enforce. And so the courts here, they create case opinions. You might read court opinions, but those opinions are always interpreting and enforcing. That's one of the critical points about Japan's system. And so because of that, the system is considered to be more stable. We see a lot of headlines recently, oh, Japan has this hostage justice system. But you need to understand, well, what is the system? You can make these sort of qualifications about the system, but being able to define and explain the system itself is critically important, particularly to regular people like myself, right? So when you are comparing that to the US system is common law. And maybe we've heard about the common law, and that's a judge-made law. But in fact, the system in the United States, it's made up of various sources of law. The law is created by Congress. Courts interpret the law. One unique point about the United States system is that courts, meaning judges, are also allowed to create the law, quite literally create it. So now they're no longer just interpreting and enforcing, they're actually creating the law. And that law, certain areas of laws are created based upon history. How did judges and courts prior to the current court treat certain issues? And another big quality about the US system is judges have wide discretion, big power. And because they have this power, they're allowed to apply what would be the law by defining it, but then also to say that case by case, situation by situation, we will decide how the law will apply and affect the parties in the lawsuit. And so because of that, the system is more flexible. You have to know and understand these distinctions, because when you are trying to explain something like, what is Japan's criminal justice system? Before jumping to saying, well, it's a hostage justice system, you need to understand what is the structure. And so know that that structure is coming from code law. quite literally statutes that the legislature created. So judges are not creating their own process here. They're not creating their own laws. They're not creating their own system. What they're doing is enforcing the system that was already defined by either the Constitution or by the legislature. Question?
When people are saying hostage justice system, though, I don't think they're trying to use a legal term, but they're trying to probably describe a practice that's actually outside of legal norms. And so how would you kind of treat that? You know, it's not, I mean, I agree, it's actually not a precise or probably a good phrase to use, but the intent behind it is probably not to describe an actual, you know, set in stone process, but something that de facto is happening. Would you agree with that?
I think your point is well taken to say that the hostage justice system, that description, is used to describe practice more so than process. But I would say that if you are being accurate, accuracy in the way that you describe things is critically important. Because if you describe a practice, practice is also a part of process, even within the law, even within the way that the system is structured. And so if, for example, we criticize the Japanese criminal justice system to say that, well, they should have bail. They should be able to release defendants out on bail. They shouldn't be allowed to keep them for long periods of time. But that actually is process. That's quite literally the law. And so when you describe that process in the way of practice, you are automatically describing the process itself. And so I think it's always good to be very accurate about how you're describing the process. Because if you would know, this is a good lead into the next slide, that one of the next slides, that the basic structure of the courts and the basic structure of the system largely determines, for example, the way that criminal defendants will be treated. So a lot of headlines will say, well, there's no bail allowed here in Japan, and they detain defendants for long periods of time. And maybe that statement is true, but they don't talk about what is the practice in other countries. The fact that in the United States, bail can also be denied. Bail can be revoked. You can hold defendants for certain amounts of time and require them to pay certain amounts of money. There are fallacies in that system as well. One of the big criticisms of the U.S. bail system is that if you have an indigent or someone who cannot afford to pay bail, then they spend long amounts of time in jail, upwards of 2 years, waiting for their trial. So we don't see that narrative explained very often. And I think in part it's a lack of understanding about the systems, and then a lack of putting that information out into the public. So if we're talking about the court structure, the big thing to note is that in the civil system here in Japan, the courts are structured by the district courts and the family courts. Those are considered the trial level courts. Trials, that's where everything happens. That's where we say the magic happens, because the judges there, they will hear, they are the first responders in terms of a criminal process or a civil case that's being heard. So within the district courts in Japan, they have different divisions. The criminal division, the civil division is broken down into many parts. And within that civil division, that is actually where you will see many of the corporate scandal type cases happening. It's not always in the criminal division, because laws that are related to corporate governance, they split between both criminal and civil. And so you will see that at the district court level, that is the level where you can gain the most information. That is the level where the evidence is presented. Once you get to the middle level, which are called the high courts here, then those are called appeals. And appellate courts typically don't take in new evidence. They are reviewing cases for errors or mistakes that happened at the lower court level. So as far as information gathering, the district courts, they are the biggest repository or biggest way that you can collect actual evidence about some case. And so when you get to the Supreme Court here, the Supreme Court, obviously, they are the interpreters of the Constitution. They largely define rights, and they largely define access, which we'll talk about in just a minute. If you compare that to the U.S. system, this system in the U.S. has two types of systems. One is the federal or national system, and the other is the state-by-state system. But the court structure is the same. You always have the trial level courts that are district courts. That's where you have juries. That's where you will have both judges and juries handling criminal and civil cases. And so one big difference is that the district courts in Japan, they are divided by divisions, whereas in the district courts of the US, the judges, they are trained to do both criminal and civil cases. So they go on rotation. So you won't have just one judge that basically hears only criminal cases, or one judge that only hears civil cases. They're trained to handle both types. When you get to the middle court, it's the same structure. On appeal, they only hear mistakes in the law, mistakes in interpreting the law. They don't hear new evidence, and so on and so forth up to the Supreme Court. So how does this work in relation to civil systems and common law system? If you have a civil system in Japan, you see where you have high courts and the Supreme Court, it says create precedent. Precedent is a legal term. It just basically means that the lower courts, all the judges, are required to follow whatever the high courts say, quite simply. But in Japan, they're just interpreting and enforcing. In the US, they're also creating law. So if you have a type of lawsuit, for example, if we were talking about defamation or libel lawsuits, in the United States, that's based on a concept called tort law. Has anyone heard of tort law? Raise your hand. Okay, everybody, I hope you have. It's good if you have. So tort law is basically a civil wrong. It's basically when you're trying to seek a money damages and you want to collect based upon certain types of wrongs that have happened to you. So defamation falls under tort law. Tort law in the United States is defined 100% by case law. There are no codes, zero codes or statutes that govern defamation in the United States other than the Constitution, right? But in Japan, defamation is governed by code, 100%. So you see the differences in being in a code country versus a common law country where you have stability in defining the law, enforcing the law, and saying what it is. Whereas in the United States, you have to research to understand those areas of law that are just developed completely by judges, not by the legislature or parliament. Okay. So if we're talking about some of the specific characteristics of Japan's legal system, if we're talking about the criminal system, we typically see that there are lower crime rates, and in particular, lower crime rates related to corporate scandals. And when I say corporate scandals, I mean the white-collar crime, those crimes that are occurring that are not violent related, and they are typically involving handling of money or the handling of corporate structure for companies. So here in the criminal system, we have prosecutors that work on behalf of the government to uphold and enforce the law. That's a part of their mandate. They have wide discretion to decide when to charge or not to charge someone with a crime. I think everyone knows, it's no secret that the conviction rates here are high. They're over 90%. And that is in part because they have a system of securing convictions through confessions. That's the primary way that they are disposing of cases in the criminal realm. Here in Japan, we have the panel jury system. That's 3 judges will decide those cases at the trial level. Or in criminal cases, we have the lay judge system that was introduced 10 years ago, right? If you think about Japan as a whole, it's not a very litigious society. They don't run to court at every turn that they get. And in fact, many cases are not handled in the court system. They're settled, or if it's the criminal system, they are settled, but it's by a plea deal instead of by a money settlement. So if it's a civil litigation, then the judges have big power to handle the investigation portion of a case. And what that means is, if a case is filed in a civil matter, now you have cases usually between individuals or companies. A plaintiff is the person bringing the case. They will bring the case, and then when you have to gather evidence and introduce evidence to support your side, all of that process runs through the judge. In the United States, it's the complete opposite. The judge doesn't get involved in the sharing of information between the 2 groups unless there's a problem. Somebody refuses to give over information, or someone is violating the ethical standards of turning over information in a case. And so what you see here is the civil system is tightly controlled by the judge. Information is controlled by the judge. Access to information is controlled by the judge. It's very difficult for, even in the criminal side, for defendants to get information. They have to request it. That request has to run through the judge, who reviews it before it actually gets released over to the other side. And so because you have this tight controlling of information, it can be difficult to extract information or what would be the evidence in a case. We see that happening even in the Gone case now, right? They've had several hearings and proceedings. The prosecutors are gathering evidence, but we've seen very, very little of what evidence the prosecutors actually have against Gone and Nissan, right? Question.
Can I just ask quickly about the tightly controlling? Good to see you, Daniel. Daniel here. Just about tightly controlling the information. What are the grounds by which a judge might say, no, you're not to hand that information over to the defendant? What are the sort of norms about how much information the defendant should get about what they're accused of?
So particularly in the criminal system, the information is controlled again by code. The Code of Criminal Procedure defines the process for how information gets released. So this is what I mean again. Judges are not just creating and making up their own rules. Yes, they have discretion, but they're following that based upon their interpretation of criminal procedure code. So the code will say the process is the prosecutor must file their case. Then the parties must have a hearing. The judge will hear the arguments of the parties, and they will first explain what are the charges, for example, against the defendant. Then the prosecutors will continue to investigate and gather evidence. The defendants will make a request, not directly to the prosecutor, but to the judge. Please allow us to see these categories of information. Then the judge will consider the request, ask if the prosecutors have the information, and the prosecutors will turn that information back to who? The judge, who reviews the information and then decides this information should be released to the other side. It's quite interesting, right? Yes.
I don't understand that the defendant doesn't have the right to see all the evidence against them.
The defendant does not have the automatic right to see all evidence against them. But that's also true even in the United States. It's not that the defendants have the right to see every piece of paper that is that is in the prosecutor's file. They have a right to see relevant information to that case. So the prosecutors, or if the civil case, they're gathering a lot more information than will actually be released. But the standard in both Japan and the US is that you have to ask for and request of relevant information, not all information.
Oh, so when would, like, in what kind of scenario would the judge say, like, no, you cannot give this?
So for example, let's say that we're dealing with this, the Ghosn case. Nissan is a defendant, and Ghosn is charged, and as well as Kelly, Ghosn's sort of right-hand person, was also charged. And the company might have, for example, financial statements running back the last 50 years. If the defendant were to request, please give me all of your financial statements for the last 50 years, that predates when Ghosn actually was a part of the company. And so that information might be viewed as not relevant to the current proceedings. So there has to be a direct tie to what are the charges in a criminal case, to the evidence that's supporting the charge, and if it's a civil case, it's a similar idea. What are the claims the plaintiffs are bringing, and what evidence is used to support that particular claim? Okay, yes?
Is the fact that judges turn down requests for information, would that be disclosed to the public?
So I think it's not something that's readily disclosed to the public because, frankly, that's just a normal part of the litigation process. So the way that you would find out if information or requests are being made and then turned down, you need to go to the hearings. Go sit in the trial court and listen to the hearings that are occurring. The more that you sit in on the proceedings, the more that you can see what requests are being made and denied or accepted, that sort of way. That it happens within the hearings. Okay, yes.
Anna, sorry, just a quick point. If you're going to ask a question, can you wait for the mic because it's recorded?
Sorry. Yes, or I'll repeat the question. Yes, I will do. Okay, so if we're talking about taking a bit of a turn to understanding the basic structure of the courts here in Japan from both a civil and criminal perspective. Now we're going to turn to what are your rights and your protections under the law, as well as what is the potential of your exposure to liability if you are reporting here in Japan. And so it's within that context that we'll start talking about protections and rights to access first. And so if you were to look at the Japan Constitution, it has a very generic language. Yes, you are allowed to have freedom of assembly, freedom of speech, free press, and other forms of expression. That is very similar to the types of language that you'll see in many other constitutions in other countries. It's the interpretation and enforcement of that provision that becomes the subject of problems to occur. So in the US, for example, we have this idea of right to free press, right to free speech. Those rights are primarily defined by judges, by the court. Here in Japan, the Supreme Court is tasked with interpreting and primarily tasked with interpreting what this provision means. And so what we see is that not so much subject to just what is the law or interpreting the law, there are all these other implications such as political pressures that will happen, which then defines what is your actual right and protection under the law. And so with that, you have the idea that you can have free speech and free press, but I think that Japan ranks fairly low as far as how those rights and protections are enforced and defined. And so the way that you would think about protecting your rights or having them further defined is you would have to be proactive to do that. File a lawsuit. That's the only way it happens. File a lawsuit asking for your rights to be defined and your rights to be explained under the law. That's the way it works. So we've seen in certain areas where lawsuits to ask the court to please define the rights that we have as reporters, they've come up in a couple of pretty famous occasions. One is by a colleague of mine. His name is Lawrence Rapetta, and he moved back to Washington State recently, but he so famously filed a lawsuit requesting to take notes in courts. So prior to him filing that lawsuit, no one was allowed to take notes within the courts. And you're certainly not allowed to videotape. And that's in part because some of the other rights and protections, particularly in criminal law, you're trying to protect the identity of defendants. You're trying to protect the process and preserve it in a sense. And so because of that, courts have been somewhat closed. So now you can take notes when you walk into a court. And that is important because it helps to show your access to information, your access to the actual justice system. The other area that we see is access to information. And so what happens is there is an Information Request Act that you can request certain types of information. Usually that information is heavily regulated in a sense. You can make a request for information in America. We call them FOIA requests, Freedom of Information Act requests. A FOIA request is very similar to the requests that are made here in Japan under the Information Disclosure Law. But part of the tension and the trouble that you run into is you can make a request for documents, access, and then the documents will come back heavily redacted. They're just completely blacked out, and then you don't have access to information. So typically, if you are suing for the right to access to information, the courts have defined certain categories of information that you cannot have access to. That's primarily related to the names of criminal defendants, juveniles in particular. Juveniles that are on death penalty, that are on the death row, that information is not available. Victims of sexual assault or crimes, usually that information is redacted, it's not available. PIP information, we call that personal information protection, PIP information, which is medical records, information that would go to your passwords to your computer, things like that. Heavily redacted, you're not allowed to see it. So the one thing that I always try to encourage is if you feel that your right to access is not being honored, then the only way that you change the system is by challenging it. And perhaps in some sense that's an American sort of way of doing things. But otherwise, no changes occur. No changes occur until we try to disrupt the system, right? And so because of that, you always want to think about using the courts to your advantage to actually uphold what should be your rights to access and to protected free speech, okay? Yes?
Sorry, I'm new here. Is there any system in Japan, like in the States, you have the PASER? Is there any way to access to the document of any litigation process?
That's an excellent question. So the gentleman asked about a system called PACER, P-A-C-E-R, in the United States. And in the US, you have access to certain online resources, And those online legal resources are primarily organized through a system called PACER that gives you access to court filings and what's called the docket. The docket is the court listing of cases that are happening. All of the records that are made public, they're put up into this system. It's a subscription system, but it gives you such wide access to literally read documents and to see all of the court filings. Here in Japan, we don't have that kind of system. PACER does not exist here in Japan. For example, if you wanted to know, well, what cases are going to be going on today? How do I find out what's going to happen on Thursday for the docket? Then you go to the Tokyo District Court website. It literally has a search tool that will allow you to search the departments, like the civil department or the criminal department within that court, and it'll pull up the schedule for, okay, this kind of case is happening. One drawback to the system here is that they don't use court names. Everything is by number. But if you understand the court system well, how it's organized, then you can just call the clerk's office and you can find out in the civil division, okay, are there any trials happening? What's the subject of the trials? Is it related to the Financial Securities Act? Is that tax accounting fraud? Like that style. What criminal trials are happening today? Most of the criminal trials will be something that's a very small, like a theft or maybe assault, but you can see the listing for the types of matters that are being handled. Go to the court. And then that's how you can see what's going to be happening. It's very similar to the what information gets disclosed during the hearings. So no, they don't have that kind of system, and it's honestly primarily designed to protect the system, protect information from being released. That is the idea. Okay. Okay. So if we're talking a bit about I wanted to compare. We were talking about this idea of how do you protect your rights, or how do you try to enforce your rights?
Has just ordered the White House to give Jim Acosta from CNN his press pass back, at least temporarily. You're right. Remember, there was a whole controversy that happened when Acosta refused to give the microphone back to a White House intern in an effort to continue questioning the president after the president wanted that questioning to stop. ABC's Cheyenne Hazlitt has more on this developing story. Cheyenne?
Hi, Diane. Yeah, so we're outside the U.S. District Court today. We just heard a ruling from a federal judge saying that Jim Acosta, CNN's chief White House correspondent, will get his press pass restored immediately while we hear the case progress. So the judge made clear that today he was only looking at the factors that went into Acosta's due process under the Fifth Amendment, not adequate due process given by the White House. So he didn't yet have to touch some other aspects of the case, like whether or not there was a First Amendment violation here. But this is what he said at the end of his ruling. He said that he was granting the application for the temporary restraining order, which will give Acosta his press pass back. But if at some point, after restoring the hard pass, the government would like to move to vacate the restraining order on the grounds that it has fulfilled its due process obligations, then it may, of course, do so, and I will promptly address that and the remaining basis of the temporary restraining order. So this is in the interim while the case progresses.
Okay.
All right, that's still...
So I wanted to show this clip because it's very interesting. Sorry, it's a blank, but if you look at the statement that CNN released about trying to restore Jim Acosta's press pass, this is legal process in action. And when you think about that, he immediately, I think within hours of having his press pass revoked, ran to the court. He ran to the court and asked the trial court judge, please issue what's called an injunction. An injunction is essentially a court order asking the judge to define the rights of the parties or to ask the parties to do or stop doing something. In this instance, his press pass to the White House was revoked. And so the Jim Acosta, as well as CNN on his behalf, went to the court and asked the court to please restore the pass. That is both defining the rights and then also asking the court to force the White House to do something. So what's particularly interesting is that the court didn't get to the actual issue about First Amendment rights to free speech and free press because the White House violated the process of his ability, Jim Acosta's ability, to report and to have access to the White House. And so the court was commenting about that without actually saying, well, we're going to define and describe what are your rights under the First Amendment. Here in Japan, there is also the mechanism of injunctions, making an injunction, which is just a court order asking for something. So when you are filing a lawsuit, you don't have to ask for an injunction, but that's the procedural mechanism that you can use in order to have the court define your rights. Okay, questions? Okay, so if we're talking about exposure to liability, we're taking a hard left to go from you should champion your rights by filing more lawsuits here in Japan to what is your potential exposure to liability. I'm going to focus primarily to defamation, because those are the types of lawsuits that typically media houses or individual journalists will be subject to. So in Japan, Japan has something that's called defamation. You might say libel, but just know that the technical names, libel refers to printed material, slander refers to oral, so like a TV, vlogs, blogs, things like that. And so here in Japan, there are two types of defamation. One is criminal and one is civil. Typically, you'll see civil defamation filed against media houses as opposed to criminal defamation, and we'll talk about that in just a second. One of the things that you should be aware of is that your exposure to liability can also come in by way of violating privacy laws. So if, for example, you were to publish a news article that said the name of a juvenile defendant that's on death row, then you could have a criminal prosecution against you for disclosing that information. That typically happens when it comes to juveniles, or if it's protected information like you publish medical files of an individual. The other is what's called it's a special secrecy law that was enacted, and this law particularly pertains to when state secrets are released and exposed. And so what you should be aware of about this particular law is that they carry criminal penalties. And usually it has to do with criminal penalties of a whistleblower, basically publishing state secrets. And but something that you should be aware of is that if the journalist is pushing too hard, pushing the whistleblower to expose those state secrets, then journalists can also individually be charged with a crime, and that carries a penalty of 3 years. We have not seen that particular law applied directly to journalists yet, but just know that the lawyers' associations and various legal watchdogs have been screaming to the hills about how this law suppresses journalism. And then the final is a technical criminal procedure law that relates to the releasing of information from a trial. So you had asked about how do we know what information is getting released in a trial or what information is getting denied. Well, under this criminal procedure law, if you misuse information, misrepresent what evidence is actually being used within the trial, then you can be brought up on criminal charges against you. We don't really see this law enforced that much against journalists, but just know that if you are reporting on criminal trials, you have to be really accurate. Don't include names too much, names that have not already been released to the public. Don't include names of victims of sexual crimes. Don't include names of juveniles. It's very important because the idea is that you want to protect the process, protect the individual from the public knowing about these kinds of very private matters, okay? So we want to take just a quick look at tort defamation. Tort defamation, this is civil, not criminal. And this is the type of defamation that is typically brought against media houses. A lot of times we will see criminal defamation brought against online bullies, or if someone is an individual posting on social media very terrible things. But civil tort defamation is a tool, I think, a powerful tool that's used against journalists because it can carry heavy money damages. Japan's legal system, on a whole, Japan, they don't do big money judgments like how they do in the US. You'll see $30 million for some case. Here, a tort defamation lawsuit a typical tort defamation lawsuit will be worth maybe about $50,000 US. But if it's a large company like Uniqlo, for example, they filed a lawsuit against a journalist because the journalist wrote a news article saying that their working conditions in China were terrible. And they filed a lawsuit for 2.2 million yen, which is very, very high, right? So the points that you should remember about defamation. The focus is primarily on damage to reputation. Reputation is extremely important from a cultural, legal, and business perspective here in Japan. And so when you're thinking about defamation, a plaintiff like Uniqlo will file a lawsuit and say, well, you damaged the reputation of my company by publishing this terrible article about how we have horrible working conditions in China. That damage to reputation then turns into damage to their bottom line. And so when you're thinking about damaged honor, they say that if you intentionally, do you see the word negligently? Negligence is a legal term. It's a legal concept, in fact. And so you can have behavior that's intentional and behavior that's unintentional. Negligence is unintentional behavior. Okay, so you can intentionally or negligently infringe on someone's right or their legally protected interest. Legally protected interest, that is damage to reputation. Okay?
Yeah.
Yes.
Sorry, I just wondered if there's any protection in the law for defamation of journalists, themselves, the reputation of journalists. So we had a workshop here about 2 years ago, which was about trolling of journalists, which is becoming an issue everywhere. Anonymous trolling in Japan is particularly bad. And we were advised by a legal counsel, Japanese legal counsel, that there was no recourse in the law, basically, to take anybody to court or to take Twitter or any of the platforms that host these people to court either. I wonder if you might comment on that.
It's a bit difficult, the relationship of journalists, the journalists here and of the politics that sort of oversee journalists here. And so if you think about the idea of a journalist saying, well, my reputation has been damaged, then I think the political response is, well, but that's your job. You spend all of your time just presenting information about companies and individuals. But the recourse is that under defamation law, civil law, you're allowed to file lawsuits. There's nothing that prevents you from filing a lawsuit. You have the same rights as any company. Now, the likelihood that you could succeed in that type of lawsuit is going to become a bit more difficult. It's almost in the same way that in the US, defamation, when public figures like Trump, they decry, oh my gosh, the media, they're so terrible, they're making me look bad. But you have a hard time as a public official saying, well, my reputation is damaged because you're public. So it's a similar concept in that way. Yes, go ahead. Mm.
What about if your story is not published in Japan? Different country, are you subject to any defamatory lawsuit?
So the interesting point that I mentioned earlier about defamation is that it's not just in print, it's also oral. So you have libel and you have slander. So even if you didn't physically publish a printed article, but you said something, you went around in the public telling everyone Uniqlo has terrible working conditions for their workers in China, that can have the same legal effect. So even though Japan's law doesn't make the distinction between libel and slander, both of those concepts exist within the law, okay? So if you are sued essentially for defamation, one huge point is that the burden of proof is on you as the defendant. Typically, in a civil case, plaintiffs are required to prove their claim. You have to prove why the defendant defamed you. But in Japan, the burden of proof is shifted. The defendants, they have to disprove or show, I did not defame you. That creates a massive, heavy burden on you. And so because of that, the court is always looking at three elements of the law. That is, the allegation or the statement was of public concern. The statement was made for the public's benefit, and the statement was truthful. Another point about this particular law is that if the defendant fails to prove all of these elements, you can still be found liable. So even if you present a true statement, the statement is true, but it's not a public concern, then you can still be found liable. In the US, for example, we have tort civil defamation. The plaintiff is required to prove all of these things, and if they don't prove their case, they lose. So here, the shifting of the burden is really, it's quite interesting to see the literal opposite treatment of how someone like a journalist as a defendant might be treated under the law. Okay, go ahead.
Just on that, how broadly or narrowly has that been interpreted, the public concern and the public's benefit in cases to date in Japan?
So it depends on the topic. So matters, for example, that would have to deal with a sexual assault by a CEO of a company, or a marital affair by the CEO of a company, that might not be considered a public concern. And so really, when you're looking at the law, most issues are related to whether the allegation was true or not true. And so I was going to discuss this a little bit later, but I'll just tell you now. The way that you can help to support your position in this type of case to prove your claim is, as a journalist, you should take very, very, very detailed notes. Take notes about anything that you've interviewed or your way of investigation, because that is treated as evidence that gets presented to support your claim. If you take notes, we've seen previous cases like the Uniqlo case. The journalist presented almost 100 pages worth of just notes about the case. That included interviews of some of the workers at the factories for Uniqlo in China. That included interviews from executives. And because those notes were so detailed, the court dismissed the case against the defendant. The other is, as much as possible, try to conduct your interviews in person instead of over the phone. If you can conduct your interviews in person, it shows that you are having sort of journalistic integrity in the way of investigating. You're not just casually supporting rumors or things like that. It goes to show the level of seriousness that you're taking in investigating the matter. Presenting evidence that you actually in person interviewed someone to support whatever statements you made, that helps. Okay.
But in the case of the reporter showing notes, the burden of proof was on Uniqlo, though.
The burden of proof
litigant
is on the defendant,
Oh, really?
on the journalist,
Okay.
right?
So that actually, does that negate essentially the ability of a reporter to protect sources?
That's the problem,
Yeah.
right there.
Yeah, okay.
That's the problem. But what you do is you just request to the court, please keep this information private, not publicly disclosed. So,
Litigation side.
especially, you can make the request that we only want to present certain information to the other side, and we only want to present certain information to the public, to the public. The judge always has the ability to see everything, always. But the judge also has the ability to control who has access to that information. Okay? Go ahead.
Just to kind of jump on that, but like are there chances of the judge then giving that information to the other side and then?
Fairly high, because it's relevant to the other side. But you're weighing that against the idea that you're going to pay $2.2 million in damages. You're weighing that against the idea that you're going to go through 2 or 3 or 4 years of litigation. What's the toll does that take on you? What is the toll does it take for you to hire a lawyer to defend you? So those are the sort of pros and cons, right? It's not fair, but that is the system, okay? Okay, so Sophie, did you have a question?
Yeah.
Yes.
So you mentioned earlier the way that the judge will decide about this burden of proof is 100% in the civil code.
It's in the procedure code. So if it's a crime, the case is a crime, then it's the criminal procedure code.
Right.
If the case is civil, then civil procedure code.
And then in the case of the tort defamation lawsuits, how often can that code change, and how has it changed? What made it change?
So the interesting point about civil code legal systems, is that they're very stable. You rarely see changes in the law. Whereas in a common law system, because the judges are making law, Congress is making law, you see changes all the time in the code. So here, we rarely see changes to criminal procedure or civil procedure code.
Like since the advent of kind of new media?
So new media, like a social media, online sort of things, no changes have happened related to those issues for criminal or civil procedure code. Okay? Okay, so the thing that you want to think about in terms of liability would be money damages, and the other would be an injunction. Injunction meaning you are prohibited from printing or saying anything about the statements that you want to publish, right? So we see oftentimes, if the company especially feels that they are being maligned in the public, too many negative headlines are being generated, then they're going to scrutinize the statements that you're making. And in tort defamation lawsuits, each statement is, in a sense, a claim. Each statement can be a claim. So they will look at every statement to see, are you supported or not? Can you meet your burden of proof to show that you did not defame someone? Okay? All right, so with that, all of that in mind, that's a lot. You guys are good law students. So you've learned a lot about the system. Go ahead.
What are the laws regarding recording in Japan? Oh, sorry, thank you. The laws regarding recording in Japan, do you have to have consent from both parties, or how does that?
So it depends on what you're recording. So for example, you're not allowed to record within courts. Court proceedings are closed. Unlike in the US, court proceedings are actually quite open. They don't usually allow videotaping of court proceedings and things like that. You have to get permission from the court first. If you're talking about recording information, then you have to be careful about violating privacy laws. That is the trouble. If you are recording information that is going to then expose private information, then you actually can be criminally charged for that. So you should be careful about recording. Get permission is the basic idea. Get permission. You're not allowed to secretly record. Okay.
Is it illegal to secretly? I mean, I imagine this won't come up, but just because I'm curious. I mean, is it actually illegal without the permission of both parties? Like, say you have a conversation. Let's say hypothetically you had some kind of a system that automatically recorded your conversations, like the Nixon White House or something. I don't know.
Yes.
What would your legal liability be in that situation?
So legal liability, it's a funny thing in the way that a liability occurs. You have to know that something is actually happening, like I'm being recorded, in order to then go and ask the court to enforce your right. So it falls under criminal liability and potentially civil liability, because you are violating privacy laws. You could be violating secrecy laws, the various laws that I've been taught that I showed you earlier. So it just largely depends. The idea basically, though, is that you should not record without permission, because you could be subject to criminal liability if, for example, the person that you're recording reports you to a prosecutor or the police. Then the prosecutor can decide if they're going to charge you criminally under some violation of law. And then it depends. So that's what I mean about being careful about violating both criminal law versus civil law as well.
So just quickly, in the U.S., for example, I mean, it would be quite common to do some kind of hidden camera investigation or something like that, where you would, that kind of thing. Don't know if that's something that really happens here in Japan or not.
Okay, so let me give you this really very quick example. There is, I believe he is the owner of an NFL, National Football League owner, and he went to a massage parlor, I think in Florida, maybe it was Florida, and he was secretly videotaped doing illicit activities, and he was later charged with a crime because the police, the enforcement authorities like the FBI, they were already investigating this particular massage parlor for doing a prostitution. And so the videotape, the prosecution wanted to use that videotape and disclose it to the public, that this videotape is the evidence of this owner's crime. And so the owner went to court, and literally last week the judge ruled that the videotape could not be used as evidence in the case. So it definitely depends on, it's very contextual is the reason why I'm saying that. Yes, go ahead.
Just a quick,
Sorry. A quick comment more than a question. This came up in Japan, didn't it, last year, because the vice finance minister was caught on tape harassing a reporter for Terebi Asahi.
That's right.
And it didn't, I don't think it became a legal issue, but it certainly became an ethical issue. A lot of people said, a lot of people criticized her for breaching the ethics, I suppose, or some kind of ethics. By recording this guy without asking his permission, her defense was, that he was a serial abuser, and this was her only chance to prove it to her employers.
Right, and so in that particular situation, in fact, recordings, people will record other people doing things, criminal acts, whatever, not criminal acts, in both the civil and criminal context. But you'll notice there's no prosecution of that particular act. And I think it's largely depends on politics, and it largely depends on who's being recorded and under what circumstances are they being recorded and why are they being recorded. And so that's the reason why I don't give you like the hard answer, is because it's really contextual. Okay, yes, go ahead.
I just had a question in regards to interviews where the subject knows they're being recorded, where you have a camera in front of them. Do you typically need consent forms in Japan, or is the fact that they have a camera in front of them an implied consent, or do you need kind of a verbal consent every time that you conduct an interview with someone?
You can't give implied consent, but you can give verbal consent. Oral consent or written consent is required. And so if you're going to record someone, like tonight, you just by email gave my consent to be recorded and to be put on the internet. I hope not into too many places, but like that style. So implied consent is not allowed, and in part that's because you're getting back to the potential disclosure of protected information, privacy laws. That is the biggest danger about recording and then putting those kinds of things on the internet without permission, for example. Okay, yes.
I know, for example, because of these issues, the Asahi Shimbun I used to belong to prohibit the reporter without getting any interviewed, without getting the permission of the being interviewed. And I know the New York Times has the same rule. Now, as for the TV Asahi's power harassment type of thing, there are many power harassment in the sports organizations and everything in Japan. They can just do it, and they don't have to use it for court purpose. Just say,
it's actually true.
Here's the record, I have it, but I'm not going to use it for any purpose. And everybody believes, just hearing that it's being recorded, that's enough, so you don't have to bring it to the court.
It's true. And so the big difference is even if you are recording, what you do with it is actually what matters more. You might have 10,000 recordings of whatever, but it's until you start putting it out into the public or showing it to other people, then that does things like open you up to defamation. It opens you up to violations of privacy law. You could be criminally prosecuted under the state secrecy law, things like that. So it's what you do with the information that I think matters more than the fact of you doing it. So this is where you see a lot of sort of self-policing and internal protocols in order to, I think, in a sense, protect you from opening yourself up to liability, right? So it's with this context in mind that I want to spend just a little bit of time to talk about the way that we would report on corporate scandals. This is just an example, but I wanted to make one point, is that because the public, we're not aware of the issues that are happening within the courts. We're not fully aware of when someone is violating the law or violating public norms. We only tend to see reporting of these huge, big scandals, and not so much reporting about the everyday legal issues that actually will have a wider impact on people. So at the end of the day, Ghosn was indicted for violating several crimes, but he also represents the 1%. And so he does not have the same issues legally that the everyday citizen would have. So if there is a lack of dedicated reporting to just all of the other legal issues that are happening, then that means there's a lack of public knowledge and awareness about the things that actually have a bigger impact on their daily lives than these huge, scandals that are happening. So I think we all understand that in Japan, corporate governance is such a huge, huge issue. It's been an issue for the last 40 or 50 years, going through ups and downs, the bubble era having massive, massive scandals, to the Lehman shock, and then now to a lot of the, in particular in Japan, accounting fraud, tax fraud, underreporting, things like that. So I want to just take a quick look at those instances of when we do report on corporate scandals versus not. So when we're talking about scandals, typically, if it's something smaller, like I don't know how many of you heard of, maybe 3 or 4 years ago, several local hotels here in Japan were accused of falsifying their menus. They were basically saying that we have foie gras on the menu, but actually it's like pork meat. And this was like actually a very big corporate scandal, and it received very little attention. It certainly didn't garner international attention, but that is an example of a situation that would impact everyday people. People going to hotels paying huge amounts of money for not so good food, right? So not every scandal that is huge in the way that GONE is reported, and in fact, those types of violations of law are severely underreported. What we've also found is that in maybe the last 15 years or so, prosecutors have not been charging companies and individuals with violations of white-collar crime. It's on the decline, in fact. And that, in part, is because corporate governance is supposed to be improving, and also in part because companies will install internal protocols to police themselves. And so when companies do what their job is supposed to be, which is install internal protocols, then that doesn't get reported at all. We just literally, as a public, we won't know that information. Whereas when we are talking about corporate scandals that are reported, that primarily has a lot to do with the legal players. How are the prosecutors charging? What is their mandate in charging? So, for example, in Japan, one of the areas of violations of law that we've been seeing more prosecutions has to do with mail fraud and wire fraud, and being able to transfer monies overseas, things like that. And so we'll see a lot of reporting in those areas. And that has a lot to do with the mandates that the prosecutors are receiving about what are the most important issues that we should be dealing with or tackling. So if we are seeing these kinds of mandates from prosecutors, then the public won't know that unless you tell us, right? You control the information largely that gets released. So people won't necessarily know why, if they go to Shinsei Bank and the bank, it keeps asking you every time to verify, are you sending money overseas? Have you had any contact with criminal organizations here? They might not know why that's actually occurring, but it's occurring because the government mandated that those prosecutions happen. So this is what I mean about being able to report on the legal issues that affect everyday people, everyday things that are happening. So if we are looking at the sources of corporate law, particularly white-collar crime, then in Japan, you always want to look primarily at the Whistleblower Protection Act. I think whistleblower, that idea is fairly apparent. You'll find that the laws for white-collar crime are largely controlled by industry. So the automotive industry will have different types of laws that will apply. If it's related to accounting fraud, tax fraud, underreporting, then usually it's a violation of Financial Instruments and Exchange Act, or it's a violation of the Company Law Act. So one very interesting point about Japan is that Gon, for example, was charged criminally for breaches of trust and loyalty. That is, in a sense, company law. And that just means that he violated the trust and loyalty in the sense of doing actions to undermine the company itself. Here in Japan, those carry criminal penalties. In the United States, for example, those are only civil penalties, or primarily civil penalties. And so because you have these differences in the way of code law versus common law, for example, you'll see that's the reason why Gon first came into contact with the criminal system. If this was in the United States, then he probably wouldn't have come into contact with the criminal system at all. It would have just been civil liability. So understanding the sources of law, where the law literally is coming from, is critically important for your reporting. Yes.
So all the charges against him are criminal?
All of the charges against him are criminal.
But
yes.
they're, the penalties, et cetera, are controlled under, I guess, a code, a civil code.
Under a criminal code.
It's under a criminal code.
That's exactly right.
But those are all written down, basically.
That's right. It's all statutory.
Statutory, yeah.
Whereas, and we'll get to this in just a second, in the United States, for example, this same type of case would have been controlled primarily by the Securities and Exchange Commission, which is just a federal government agency. And the SEC has the power to charge criminally and civilly, but this type of case would have fallen under civil penalties. Those penalties would be very high, in the millions, but you're not having to be arrested and to go to jail. And so it just, because the systems are different, we're automatically starting from a completely different perspective here in Japan. So there might be criticism about, well, he was arrested, but it's because the literal source of law is code law. They're just enforcing the law that the Diet created. Okay, go ahead.
Sorry, thank you. So is this, does this make any difference if it's not an individual that's being charged for breach of trust versus let's say an institution like Nissan itself was accused of blank, or
it makes a difference.
Right.
So in company law, this is in the US or Japan, breach of trust and breach of loyalty is related to an individual. So it's the individual's responsibility and actually a part of their duty under the law not to undermine or take actions that are against the company itself. And so Nissan was actually charged, you know this, in this case as well. But Nissan is charged for violating the Financial Instruments Act, not breaching trust against itself. And so one thing that doesn't get reported that often is the case against Nissan, or the fact that Nissan would essentially go to the prosecutors and they become their own whistleblower, and then that in turn does what? They are exposing themselves to liability because now they're charged. So if we're talking about this idea of how players are represented in the media, particularly in corporate scandals, we are always thinking about the ways of what that narrative is. And we're going to look at this in just a second. But oftentimes, if we're looking at a case like Nissan, Gon starts off as the villain, for sure. Troublemaker. You're trying to hurt the company. And in Japan in particular, reputation is everything. So if you do something that undermines the reputation of the company, that can also be a breach of trust and loyalty. And so when you're thinking about the company, they are starting off as the victim. They're saying, oh, we were just duped. We didn't have any idea what was happening. And so the narrative that comes out is quite interesting. In the Olympus case, for example, Mr. Woodford, he was the incoming head of the company. And I think 2 weeks into him being the head, he saw some irregularities within the accounting of the books of Olympus, and he reported this to the board. He was promptly fired. He wasn't brought up on criminal charges, but the company treated him as a villain. But the interesting narrative is that once this got out into the public and news outlets started reporting, this happened in the foreign media before it actually happened in the media here in Japan, he was hailed as the, what, hero. Only Mr. Woodford felt compelled to speak out. He's the disruptor. He's the one that is going to expose the bad behavior. The company was considered the villain. When you have New York Times headlines saying there was a cover-up, that is automatically suggesting bad behavior. And remember, if you are the ones controlling the narrative, you say what goes out to the public is going to take what you say at face value. Then now we've got the whistleblower as the hero, the company is the villain. When we move to the Ghosn scandal, then that narrative switched completely. When we first saw, shockingly, Ghosn being arrested in the airport, some of the first headlines were, he's been indicted. Now, what's interesting about the Asahi Shimbun's first set of headlines that came out, very objective, reactive, fact-based headlines. This happened, this happened, this happened. Ghosn and Kelly were arrested. And then as the narrative began to shift, now we see, Ghosn admits shifting investment. Doesn't that imply bad behavior? This is the next set of headlines that came out. And as the narrative progressed, after Ghosn was arrested and he spent all of this time in jail, now we're seeing the system itself as the villain. It's a hostage justice system. They shouldn't be detaining him in this way. And so you're seeing this commentary, quite literally, the story of how this case is going to play out in the legal proceedings happening in the headlines. And it's driven primarily by the narratives that you create, right? So it moves from that to now the company is the villain. Ghosn blames executives for playing a dirty game. There's all these conspiracy theories, and Nissan, other executives were trying to out Ghosn. The narrative continues to shift. But one thing that you can always keep in mind is that if you are doing objective reporting, in part objective reporting, proactive reporting, exposing, but also saying step by step what's happening, then you can do what the New York Times did, which I thought was fantastic. What if this case happened in the US? The only way that they could have made this kind of article is because of their knowledge of both legal systems. That is information that's powerful because now people have perspective. The public has perspective about, okay, what's really happening here? So if this case were filed in the United States, then we know that the SEC would be the first controlling decider about what kind of case it would be, criminal or civil. It would likely be civil. Also, the other agency would be the Internal Revenue Service, the IRS. So if there were any violations of tax law, then the IRS would have the power to bring civil or criminal penalties. But because this case, under the source of law, it comes from the SEC and the judge's interpretation and creation of case opinions about white-collar crime, Ghosn never would have been arrested. We never would be having discussions about the bail system. We would not have discussions about detention. It wouldn't come up. If there were criminal penalties that were applied in the U.S., then the likelihood that Gon would be detained is very, very low, especially for criminal white-collar crime issues. The U.S. Constitution guarantees that you have a right to a speedy trial, so that means long detentions are not permitted. And that is interpreted by the Supreme Court. Yes, go ahead.
I don't know how much time you have beyond.
I hope I can have like a few more minutes.
Oh, okay,
I'm
okay.
almost done.
We also wanted to ask some specific questions about what's happening with the Gon case. The pretrial hearing is next week on the 23rd. What is a pretrial hearing?
That is a very good question.
And what's going to happen?
Okay, so in the criminal system, the process is that you first start by arrest, and then you have to have a hearing to have the charges read out loud against you. And then as the case progresses, the prosecutors will investigate and gather evidence, present that evidence to the judge to review, and then some of that evidence gets released to the other side. You can have a pretrial hearing. Pre-trial hearing is just designed to narrow down the specific issues that will happen at an actual trial. Usually the judge is narrowing down what evidence can be presented in the case. The judge will also narrowly define what arguments are allowed to be presented in the case. That's the reason why the prosecutors, I think maybe 1 or 2 days ago, they amended the indictment, the charges against Gon. And that is because they are required to do so because they have a burden of proof once they get to the actual trial.
And you can have multiple pretrial hearings.
You usually have multiple pretrial hearings, and most of the time it has a lot to do with narrowing the issues that are going to be presented at trial, the arguments, and the evidence.
And are they for all the charges or just?
It might be for one charge. It could be for all charges because it just depends on how.
And the judge gets to decide sort of what charges are going to be discussed at
the next pretrial hearing.
Exactly.
Or so basically, the judge has a wide discretion and control over the proceedings that will happen at the trial court level. And so the parties will make requests such as, at the next pretrial conference, we'd like to discuss specifically maybe removing one of the charges, adding more charges, explaining what evidence gets presented related to one claim. So it just depends on how the case is progressing.
And just rapid fire here. Are they open to the public?
Some hearings are open to the public, but you just need to, this case has been so widely reported that at the district court, quite literally, you have to go there early. If you know the hearing is happening, the court clerk will give the tickets like you're in a Disneyland line, and they only allow so many people within the courtroom. That includes journalists. There's a certain number of seats that are actually available for journalists, but you have to apply to get in there.
Okay, but you don't know until the day whether it's actually open to the public?
Go on the day. You have to physically show up on the day and show up early because of this type of case.
Interesting.
Okay? Oh, yes.
Sorry, just quickly, who decides how many pretrial hearings are and when they are? Is that the judge?
There's no set amount. You must have X number of hearings. It just depends on how the case is progressing. So the judge will set pretrial hearings. Some of those pretrial hearings can also include plea agreements, plea deal. So a plea deal is basically a settlement of a criminal case. It's when the prosecutor and the defendant will discuss the individual charges and decide if there might be some dropping of the charges or if the defendant will admit guilt and then what could be the penalty. So I understand earlier there was a press conference held here. I can't remember the gentleman's name, but he gave a prediction about what would be the ultimate judgment in this type of case, and very boldly, I think he gave the prediction of 5 years jail time. Those kind of issues are not decided at pretrial unless it's through a plea deal. So if Ghosn decides to accept a plea deal on any one of the charges, then he can negotiate, in a sense, of what would be the ultimate penalty. Okay? Okay, so just quickly, I wanted to talk about, I'll get to you in just a second.
Sure,
so just quickly, I wanted to talk about just a few more of the resources that you should think about for when you are reporting. Primarily that has to do with knowing the legal proceedings. So as I was saying, showing up for the court hearings, knowing which division, and just calling the clerk to find out what cases are happening on a certain day, that can help give you information. If you are talking about resources in Japan, there is an English translation website that is essentially translated almost the bulk of all of the laws here in Japan. So if you want to know, okay, what is the Financial Instruments Act, and you want it in English, go to that website. It's really helpful. You can just do searches to find what is the law. One other point I wanted to say about your resources. When the Ghosn case first broke, many reporters were contacting lawyers from large firms here in Japan, here in Tokyo, asking please give a comment. You will likely not be able to get comment from large lawyers at large firms because they primarily represent corporate clients, and the conflict of interest is just tremendous. So if you want to get a quote about what is the legal process, what do you think about X, Y, Z, go to professors, go to legal practitioners that are solo practitioners. They have their own law firm, or they're small. They are more willing to give on-the-record comments about the case than would be large law firm lawyers. One other final point that you should consider is that if you are looking at comparative resources, it's really important that because you are journalists here in Japan, you drive the narrative of what the legal system here is in Japan. So you can do comparative analysis by going to online research databases called Westlaw or Lexis. They're subscribed databases, but they give you access to court opinions, or to PACER, which is court filings. Okay? And so the final thing that I wanted to, final comment that I wanted to make is that there are ways that you can, I think, better explain the system, being that you have the power to give information. It's always good if you can be accurate in the way that you explain what is the law and what is the legal system, including the process. Too many times we've seen incorrect statements or incomplete statements about what is the law that applies and what is the legal process that's happening in a case. Over-dramatizing narratives. So when we see things like a smoking gun, Ghosn admitted it, that's sort of clickbait. And I think it can be a bit misleading and not giving enough information so that the public can understand what is actually happening. So when you are reporting, I hope that you will consider to be more fact-based and not reporting like it's a Suits TV show that we often see. The other one is presenting only one perspective. So if you do a search of this Ghosn case, some newspapers or news outlets will literally, every headline will have the name Ghosn in it. but you never see Nissan, or you never see any other name. And so that's driving a one-sided or lopsided perspective. There are multiple players within this legal proceeding. So being able to show who all of the players are is actually helpful to us regular folks that would like to get information about the process. So with that, I just want to say happy reporting, and thank you for your time and attention. Okay. So I have the time, if you don't mind, maybe one question is, I think, all we have time for. Okay.
Sorry, I've just been scrambling around for the last 5 minutes looking for your honorary membership, which I appear to have mislaid. I just wanted, I suppose the big question, I was kind of hoping that you would give us examples of the kind of misleading coverage that you have been, you've talked in generalities. Yeah. You know, without putting names to them, do you have specific examples? Because, you know, we've all kind of been scrambling around trying to interpret this, and in my case, I've relied on what I already know or previous stories about the justice system here.
Earlier, I had, for example, shown you different, these are like sort of ripped from the headlines, quite literally, headlines that have been related to the Ghosn case. And what we've seen is that because the narrative is shifting now, so we see a lot of sort of villainizing of the company now, when it's not something that we saw before. So now it's CEO, current CEO is trying to trap and tell lies about Ghosn, or we'll see those kind of very sensationalized headings. So even when you see things like you're playing a dirty game, my first reaction is automatically, that seems like a very bad conduct. So this is just one example of what I mean about being careful about just quite literally word choice, to make sure that the word choice reflects accurately what's happening in a particular case. Okay. All right, I know it's a lot of information, but you guys did so well. I would give you an A if you were taking my torts and civil procedure classes. Thank you for coming, and thank you for your time this evening.
Thanks very much. Well, I found that fascinating and very helpful. I've been asked to remind you that this is part of a series, these workshops. They are monthly, they're free. And the next seminar will be on June the 4th. It's called Meaningful Journalism in the Digital Age, How to Produce Content for Social Media Sites Using New Technologies. It will look at the history of digital journalism and provide hands-on training. If you're a student, would you consider membership at the club? It's free as well. I believe Furuta-san will confirm that. And if you want any more details of the program itself, Furuta-san at the back of the room will give you all those. Do show your appreciation again for a wonderful talk by Tina, concise and very helpful. I feel chastened somehow. I can't quite tell. I'll go home and do a hand say. Thank you very much.
Thank you.
I was supposed to present you with your membership. It'll come.
Thank you. Yes.
Yeah.
I'll take it.